Hey, it's Bill Gross, the LA probate expert, and I've been going to LA County Court probate confirmations for regularly for over the last 3.5 years. Now, like many realtors, I've done some on occasion, but 3 years ago, pre-COVID, when the court was open, I went every day, and in the course of that process, I could pick which court had the court confirmations and saw, one or two a day for the period of 2 years. And as a result, I believe I've seen more court confirmations than any judge, attorney, or real estate agent. And I've also represented both buyers and sellers more than anybody else. There are some people who've done more listing sides that work with the county attorneys, for example, and some other listing agents. But I believe I've done more on both sides than any other agent in Los Angeles County. And as a result, this is the area of business that I see tripping up families and estates and attorneys regularly, because the court confirmation process is very particular and very few attorneys have more than one a year. And as a result, over 50% get continued, over 25% end up getting denied without prejudice. And so there's tremendous waste of time and money for families, estates, and attorneys. And what I want to do here is share with you some of my knowledge to show that I am the expert and maybe help you prepare for your next cases. Now, if you're an attorney, for free, give me a call. Let me help you game plan the next court confirmation case that you have. I'm glad to do that. I do that with attorneys all the time. That's part of the value that I present. Because I can review the documents. I basically could be a free second paralegal to help you check your case. And if you're a family and you have a property coming to court confirmation, give me a call. Let me see if I can help you make sure that all the things are done properly. Sometimes families try to avoid listing a property, not knowing that's a requirement of the case, of the court process. So let me share with you my list of 50. Now, it started at 47 when I got ready to do this video, and just in preparing my notes, I realized another 3 that I've seen over time. These are 50 mistakes I've seen other listing agents make, even good ones, that cost their clients and cost estates tens of thousands of dollars, if not more than that. I've seen properties that got overbid by $300,000 or $400,000. Money that might have been lost to the estate had some luck not intervening to save them. And I know that regularly families lose $10,000, $20,000 or more because of some of these errors. So let me go through this list with you. Number 1, not checking title right away. There is no excuse for this. Since the property has to be listed, title companies are glad, at least the ones I work with, are glad to do a preliminary title report. That will show you, is there any old trailing documents that maybe got forgotten about, any old loans that need to be reconveyed, any family members with claims on property. It's important to get the preliminary title report initially, right when you list the property, and review it for any potential alligators in the swamp that you might have to deal with later. Number 2, classic mistake during the marketing period is accepting an offer before the date published in the required publication. In order to get a property sold with court confirmation, there's a required publication process. Very detailed. I'd be glad to help with that. I place those ads for my clients for free and then get reimbursed. But it has a date after which you can accept offers. And I regularly see mistakenly estates accept an offer beforehand because they have a family member that wants to buy it or a neighbor. But you cannot date the contract until after the published date period is, or else the sale is set to be invalidated. Number 3, not identifying the difference between a court-supervised and not court-supervised sale in the listing. Many times, listing agents don't know, is a court required, is it not required, and the verbiage is a little tricky because the proper verbiage is either required or not yet required. Because we don't say not required, it's possible even with full authority, an objector may pop up and the judge may later cause a full authority case to require court confirmation. So the proper verbiage is not yet required in the real estate contracts. More importantly, though, you want to identify the process of the pre-sale different than the court confirmation process, meaning a buyer does not have to put down 10% earnest money deposit and waive contingencies on the initial sale. The initial sale is going to be confirmed at court. So you can use standard procedures like 3% earnest deposit or less. And you can have a contingency period. Then when the buyer waives contingencies and then the buyer raises their deposit to the 10%, then you file the petition for the court. Too many listing agents I see mistakenly market the property for the initial sale with a 10% deposit and waiving contingencies, which limits the buyer inventory tremendously and causes a lower price for the family. Big mistake. I see that one all the time. Number 4, pricing the property too high. It doesn't make sense to price a property high unless you're trying to avoid competition. Sometimes listing agents purposely have a buyer. They don't want anybody else to see the property, so they price it really high so no other buyer expresses interest. So I've seen properties listed 25-30% higher than the confirmed buyer. Makes no sense, especially once you've accepted an offer. You should lower the list price to the overbid minimum to encourage buyers to come in at that time.